My name is Eric Kinaitis. I am the editor of AEF Insights and the director of content marketing for the American Endowment Foundation. We are glad you've taken some time out of your day to join us. Our team of panelists today will cover the basics of estate planning. They will speak about the 6 steps involved in successful estate planning, a definition of common need-to-know terms, the information needed to begin the planning process, considerations in choosing an attorney, and the core documents that need to be prepared. Additionally, practical tips to save you time and money, as well as insights into the value of charitable giving as part of the estate planning strategy will be discussed. Regardless of your expertise, we are certain that today will include relevant takeaways that can be of use to yourself, your practice, and your clientele. Some brief housekeeping issues. If you have any questions for our panel today, please submit them through the question box that exists on the GoToWebinar control panel that appears on your screen. Although you can submit your questions at any time during the webinar, we will hold all questions until the end of the discussion. We have several minutes set aside for Q&A at the end of our presentation today. Please be assured that if your question does not get addressed on the air, we will respond back individually after the webinar to get your questions answered. Let's get this part out of the way. I won't read this slide verbatim, but I do want to provide the relevant disclosure. Today's webinar exists as a public service, and it's done in conjunction and in support of National Estate Planning Awareness Week. Although every effort has been made to have all information presented to be up to date, inadvertent errors may occur, and changes in regulation can be frequent and may alter currently known facts. Our information today is not intended to serve as formal legal, tax, or accounting advice. Presenting with us today are Phil Tobin, David Umbaugh, and Valentino Sabuco. Phil Tobin is the chairman and co-founder of the American Endowment Foundation, the largest and oldest independent administrator of donor-advised funds. Founded in 1993, the foundation administers nearly $600 million in current donor-advised fund assets. Phil, thanks for joining us today.
Thank you, Eric, and thank you, all the rest of you, for inviting me.
Certainly. Our David Umbaugh is also joining us today. He is a lawyer who practices and specializes in estate planning, probate and trust settlement, family law, and probate and trust disputes. In addition to his experience as a probate and estate planning lawyer, David is a trained collaborative family lawyer and mediator. David, thank you for joining us today.
Pleasure to be here, Eric. Thank you.
And rounding out our panel is Valentino Sabuco. He represents our partnering organization, the Financial Awareness Foundation. He is the executive director and publisher of the organization. He is also a certified financial planner and an accredited estate planner. Valentino is a career-long advocate for improving the public's and professionals' financial awareness and their financial literacy acumen. He also is a pioneer in fee-only personal and business financial planning since the mid-1970s before moving into the nonprofit space in 2008. I will now turn to Valentino with the rest of our agenda today.
Thanks, Eric, and greetings, ladies and gentlemen. Here's an outline of today's fast-paced presentation on the building blocks to successful estate planning. Estate planning is important for everyone, regardless of the extent of your net worth. It's the only way to control the distribution and management of property at your death or if you become incapacitated. It can minimize the time and cost involved with handling paperwork and in transferring property. Wealthy people may also use complex strategies to reduce death taxes and transfer costs. Those who are not so wealthy may only require a simple powers of attorney to help manage finances and health care decisions if incapacitated, and a will to pass property to heirs, and possibly a trust to provide to care for minor children and with appropriate distribution dates. Estate planning is a very important part of everyone's financial planning, even if you only require the simple will and powers of attorney. This is one area of financial planning that we'll all require someday. To help you with your estate planning and as a supplement to this presentation, we'll be emailing you within a couple of days a copy of our new estate planning book, Your Estate Planning Organizer. The user-friendly publication is filled with background information, tools, checklists designed to save you time and money and putting together in keeping your estate plan current. Some of the topics we discussed today will be covered in more depth in that publication, so that will give you additional tools. Let's see how...
Yes. If I may interrupt for just a moment, just for the benefit of our audience, they will be receiving an email tomorrow about midday, so that's when they can expect to receive their access to that particular ebook.
Excellent. Now let's see how we did on the survey. For those that you have taken the quiz that we provided, it's also referenced in the materials that you'll receive in the next day. In the estate planning area, it's estimated that over 120 million Americans don't have a current or up-to-date estate plan. That's about half our adult population. That's half your neighbors, half your friends, half your employees, half your clients, half your prospects. The cost to them and their families and the nonprofits of wasted dollars is quite significant. From the initial takers of our quiz, as you can see up in the right-hand corner here, a number of those were done by financial advisors, and it appears that the advisor community and those that were the initial pass did very good and have begun to put their estate planning building blocks in place. And they're now about ready to move into the charitable phase of their planning. On the next slide, we have a total recap of how everybody did in the whole quiz, the whole financial planning area. And the results, again, here were quite excellent. This is one of the best results that we've had in this quiz, giving it over a number of years. As to this group is primarily between considering themselves financially astute and financially concerned. But an issue here to be aware of is if the wrong challenge hits you at the wrong time, it can be financially devastating. So start taking some positive action now to plug up any of those leaks in your financial roof so that you and your family have the best chance for long-term financial stability and success. Next, we have some alarming consumer data. And as we look at where we are today, the area of personal finance and estate planning is an area that we're not, as a population, totally aware of, and we're blindsided by a lot of issues. The majority of Americans who are reaching age 70 are almost out of money. That's scary, especially when there's a good chance that a good percent of us on this call are going to live to be 100. This gives us a real financial challenge, not only for our families and our employers and our nonprofits and charitable causes, but for our government and our economy. What's in your financial future? So what happens, David, when you don't have up-to-date documents for your estate planning?
Well, quite obviously, at least in my world, it's a risk of serious confusion. If one of my clients, or for that matter myself, becomes disabled, cognitively disabled, for example, who in the world is going to be authorized to manage my funds? Is it going to require a trip to the courthouse to determine that? Is it going to be an argument as to who would manage my funds? How is it determined, for that matter, that I am disabled? We are all 7 to 8 times more likely to be disabled in the next 12 months than we are to die. And it's been my experience that the disability component of estate planning is often ignored, or at least diminished in attention. We've got other issues there on the screen. The will may be missing. It may not exist at all. Was it revoked? Was it not revoked? Are the beneficiary designations for those assets that have beneficiaries, are they correctly set up? Were they left blank? I've seen that frequently, where beneficiary designations, especially contingent beneficiaries, if the primary is not living, have been left blank, and there can be significant income tax consequences, negative consequences to that. The wrong people may inherit. The burden of any tax may be shifted to the wrong person, especially towards the bottom of the slide. There is a concern that an inheritance pours out in cash or outright to individuals that either are not capable of managing it. I've heard that the average inheritance is spent in its entirety in 2.5 years. By managing the planning well, that inheritance could have lasted for much longer and been more valuable to the beneficiary. The probate process is engaged rather than avoided, which is most of the time avoiding that cost is avoiding of cost and expense and delays that are unnecessary. So just a great deal of problems that can arise if these matters aren't thought out. A lot of times it's not difficult to think this out. It's not complex. It's just not done. So an estate plan includes both planning for two catastrophes, the disability of the individual, the risk of that disability, and the eventual and certain passing from this earth.
There are a few more problems that we might encounter, and this deals with property titles and beneficiary designations that may be out of date. This is a key item to understand, especially if you put your estate planning documents in place, because the title to the property and your beneficiary statements have a higher priority than your will does. If you hold title to your house in joint tenancy with Eric, and you will your interest in that house to your spouse, and you pass away, guess who gets the house? Not your spouse, Eric does. If you have an X listed as the beneficiary of your life insurance and your retirement plans, and you get married, remarried, and you update your will and leave everything to your new spouse, and you name your new spouse as the beneficiary of your assets in your will, but you don't change the beneficiary statements, and you pass away the next day after signing the will, guess who gets the insurance and retirement plans?
Well, one of the ways to say that is that the beneficiary designation of an asset that has a beneficiary designation trumps the will. So when I hear people talk about, well, you do an estate plan, you do a will, often that ignores 3/4 of my client's assets, because that 75% is passing by beneficiary designation, and it's irrelevant what the will says.
So that could be a really scary element, and it's a key element as time goes by when you acquire assets and sell assets and have changing family situations. And beneficiaries that might not understand that could get very embarrassed or create litigation when time comes that you do pass.
It's even a bit confusing to people which assets have beneficiaries. Certainly all retirement accounts, qualified retirement accounts, IRAs, annuities, life insurance have the beneficiary associated with it, but many banks and financial institutions now add beneficiaries to other accounts. Payable on death beneficiaries, transfer on death beneficiaries. So typically my client doesn't know which assets even have beneficiaries, let alone which ones of those trump the will.
So in a few minutes we're going to talk about some ways of organizing your thinking and paperwork so that you can see that data in front of you in an easy manner. But David, what happens if people don't have a will? What are the default rules? Is there some standards to that?
There are no standards. The question, again, is what happens if I die without a will? Well, it depends upon what state I'm domiciled in when I die. In every state, essentially, Val writes a will for me by statute. In Ohio, I'm located in Northeast Ohio. In Ohio, it depends upon who survives me. And what's really happening is Ohio, and any state, is making a best guess of what I probably would have wanted. Well, that guess may or may not be accurate. And without going through the detail of this chart, For example, in Ohio, if I had children from a prior marriage, a certain percentage of my assets will go to my children of a prior marriage, and the rest of the assets will go to my current wife. Well, that may or may not be what I intended. So without a will or a trust, I'm relying upon what the state of Ohio would guess that I wanted in that scenario. On the other hand, if all my children were of this marriage, then current Ohio law gives it all to my spouse. So it's dangerous at best to rely upon the guesses of what the state that I live in may assume that I probably wanted. It is not correct that if I die without a will, everything goes to the government, to the state. That is not correct. But what is correct is that I'm buying in. Without that will, I am electing into the state's best guess. And some of those best guesses are nicely illustrated on this slide. But again, you'll notice that in New York, for example, one thing happens. In California, a different thing happens. And in Ohio, indeed, another thing happens. So there is, without going through all of the variables of 50 states and various circumstances, everybody should simply know that by relying on a will or by not having a will, you're opting into the state's will, but for those beneficiary designations that may have been completed.
David, do things get rather fascinating when someone owns property in 2 or 3 or 4 states and they pass away with a will? Does that make your job as an attorney easier, or does it add some complexity?
That's an interesting adjective that it makes it fascinating. My clients would, or the beneficiaries, would say frustrating is more the better term. If I have a client here in Ohio that owned a piece of property in South Carolina, they have to open up a probate process in Ohio, and certainly what you're driving at, Val, what is called an ancillary, a second probate in South Carolina. So now they have not just one probate process to undertake, but 2. I remember a case not too long ago where the client abandoned, the beneficiary did, their interest in a piece of vacant property in Arizona because the cost of those 2 probates exceeded the value of the land that the beneficiary would have received had they undertaken those 2 probates. So yeah, real estate out of state is a serious problem.
Well, if you're like most Americans, over the last couple of years, you may have experienced a significant up and down fluctuation in your financial position. In estate planning, even during normal times, ordinary life changes can have material effect on your family estate plan. Unfortunately, you can't just talk about estate planning because verbal agreements aren't legal. You need to have your attorney put them in writing. Before we go on further, we're going to go over a couple of the common estate planning terms. David, what does probate mean? We hear this term all the time, but what does it actually mean?
Yeah, that's a good question. Probate is the legal process at the courthouse that the law of the state requires before the asset will pass to the beneficiary. The purpose is basically to make sure all the bills of the decedent, the person that died, are paid, that the right person is going to get the asset, and we're looking at the latest will and not the second latest will. So the bureaucratic process is put in place decades and decades and decades ago in most states that ensure that these goals are met, but at the cost and expense of a fair amount of money.
And within a will, there's executors and guardians. What do they mean? What's an executor?
Yeah,
is that an executive of some sort?
No. First of all, it ought to be clear that a will does not avoid the probate process. I find people are confused about that. Whether you die with a will or without a will, the assets, if they're in the name of the decedent at the time of death and there is no beneficiary designation, will in fact engage the probate process. Now the will, to your question, Val, the will names a person to engage to undertake that probate process, and that person's called an executor. Not a trustee, an executor. And a guardian is often designated in a will so that if the decedent, again, the person that died, has minor children, in Ohio less than 18 years of age, then the will designates who will raise those children and make children decisions since the parent has died.
And then are all trusts revocable or irrevocable? What does that mean?
Well, yeah, a revocable trust is a trust that that the creator, typically called the trust maker or the grantor, can cancel at any time. They can amend or cancel at any time. So if I put my assets, in my revocable trust, it's equivalent to me still owning those assets without any kind of loss of control or concern. It's just another place to, if you will, stash my assets. An irrevocable trust, which is much less common, but there are specific reasons to use an irrevocable, pronounced irrevocable either way, a trust. If one of those reasons exists, once I create that trust, I cannot amend it and I cannot cancel it. The term living trust on the slide is typically used to mean a revocable, changeable, amendable, a revocable trust as compared to an irrevocable trust. A testamentary trust is a trust that only arises at death and commonly does not avoid the probate process. In Ohio, we very rarely would use a trust that is inside the body of a will that arises at death because we've not avoided the probate process. You want me to go on some of these other terms, Val?
Yes, let's touch on them because those are core, and I think they'll be good building blocks for the next couple of slides and cover points.
You bet. A durable power of attorney is simply a document, if I sign it, that says my agent, the person I name, has the authority to sign my name for whatever purpose I've authorized in that document. Commonly, it says he can sign my name or she for any purpose if it's a broadly written document. Now, why would I do that? Well, primarily I would do that so that if I become disabled, somebody can step in and manage my finances without having first be going to probate court and seeking a guardianship. Very important document, can save a lot of money. The term durable means that it is effective not only when I'm living, it is effective not only when I'm healthy, but also it lasts for a duration past my incompetency. More to say about that, but not enough time in this format to do that. An advanced health care directive, different terms in different states, but it's in Ohio, for example, it's a health care power of attorney, where if I name Eric here as my health care agent, only if I cannot make medical decisions, what hospital to treat me, what doctor to treat me, what operation to permit, et cetera, whether the respirator should continue or not, any medical decision, routine or drastic, Eric can make in my stead. He stands in my shoes because I am not competent, maybe not even conscious, and can't make them. A living will is another document that it directs my feelings about what should happen, my direction really, about what should happen if I am likely to die in a very short period of time. There are reasons not to sign a living will, by the way, and there are reasons certainly to sign a living will. The term living will is a terrible term because it is not a living trust and it's not a will, yet they call it a living will. It's a medical document for end-of-life concerns. A beneficiary, I think probably we all know, is the named person in a will or a trust or a beneficiary form for life insurance or annuities, etc., retirement accounts, as to who is to receive the asset. The unified credit...
That gets a little complicated because it is the beneficiary of a life insurance policy and the beneficiary of a retirement plan and is the remainder or a gift out of a will or a trust.
Yeah, that's a really good point. The term beneficiary is so broad as to be ambiguous for people. But suffice it to say is who is intended to receive a specific asset, whether because of a will or a trust or a specific designation of a beneficiary on an asset that has such a designation. Should we go on to unified credit, Val?
Yes.
Unified credit is a tax term. Again, this venue doesn't allow much discussion about that, but basically the federal government has an estate tax, not an income tax, but an estate tax. And when I die, if my assets exceed $5.34 million, there will be tax on the excess, a tax that's approximately 40% of that excess. So it's a severe tax. It's called unified because it's combined with the same limitation on gifts that I have made during my life that are any given gift that is in excess of $14,000 begins to reduce my credit when I die. So if I gave $30,000 to Eric, that's $16,000 more than the $14,000 limitation. I just spent $16,000. I reduced my $5.34 million exemption when I die. I reduced it by $16,000. Now that's fast, and in this venue, that's as good as I can do in the time we have, but that's what it is. Now, portability is a new concept and a wonderful concept. If I'm married, as I am, and I don't use my whole $5.34 million, let's say I only use $2 million of it. Well, the other $3.34 million, my wife can use when she dies, when she later dies. So it's not lost. That excess is not lost as it used to be in the law. So portability simply means that my unused credit, unified credit when I die, my unused portion, maybe all of it, ports over, hence portability, ports over to my wife, and she can use it when I die.
One quick question can I ask? This is Phil Tobin and Dave. You said unified credit and up to $14,000. Is that annually or is that a lifetime?
That's a good question, Phil. People are totally confused on this when they come in to see me. $14,000 gift exemption is simply this. I can gift as much as I want. It is not a prevention of me gifting more.
Understood.
But if I give $14,000 or less to any one person in a year,
So
I could give you $14,000. I could give Eric $14,000. I could give every party listening to this webinar $14,000 in a year and still stay in a situation where I have not reduced my unified credit.
And you could do that $14,000 the next year.
Absolutely, and the year after that.
So that's an annual type of thing.
It's annual, yeah.
Good.
Well, David, with that as kind of a foundation, let's go over a quick overview of what the estate planning process is. Starting with people defining their goals, who gets what when, who helps with these matters, the appointments that are made, then gathering information together to be able to understand where they're at and where they want to go, and then seeking out the right attorney. Are all attorneys trained in estate planning? There's like 400,000 attorneys from the American Bar Association. Do they have your expertise?
Well, many lawyers don't deal in this area of law. I would say it's accurate to say most don't, unless you're limiting to this area of law to knock out a will off a word processor. So there are only a limited number of lawyers that focus on this day to day to day. Your chart, Val, is just an excellent one. Estate planning in my office and in any law office, I think, that does this work well, is to simply sit with the client and discuss goals. Present options. Think about it. Don't start with how to avoid probate. Don't start with tax issues. What do you want to happen to your accumulated wealth, whether it's large or small, when you die? Does it all go to the spouse? Should there be restrictions on the spouse if there's a second marriage concern? Is there a second marriage already? Are there kids from both marriages or not? Just sort through the goals. Are the beneficiaries likely to manage their assets well when they inherit it or not? Are there disabled people with disabilities that are beneficiaries? The goals are come out of a discussion. We will spend 2-3 hours with our clients, probably 2 hours the first time, 2 hours the second time, before we understand what their goals are, because it's a conversation. Then the second point of your slide is to make sure that there's a system in place. And Val, your you're more adept at that than I, to help organize the assets, the financial data, the income, the life insurance, et cetera, et cetera, et cetera. It needs to be organized. Seeking the right attorney, I believe the only real measure of whether the attorney is the quote-unquote right attorney is how much time is this attorney spending with you to think these things out. Is it a quick sale of a document, or is it a process that involves thinking? I tell my clients that they're not hiring me to write documents. They're not buying documents. They're hiring me to help them think. And the documents are just the final piece of that cake. I'm spending too much time on this slide, I'm afraid. But basically, it's a question of organization. It's a question of thinking, and eventually writing the simplest set of documents, the simplest that will accomplish the goals that were isolated in those conversations.
And then once those documents in place for the processes, they need to take care of their title to their assets and to their beneficiary designations, as we were talking earlier, and then provide some type of a location sheet or data to their close family, the executors or trustees. If they hide their estate planning documents under their mattress and don't tell anybody they have them, and they get sick or pass away, even though they may have done the right things, the tools are not there for people to help them or to take care of the next step in the process. And estate planning is forever. It's not just the creation of these documents. People's lives change, the economy changes, the laws change.
Val, before we move on to the next slide, let me add to that, because that's well said. First, taking care of title and beneficiary designations. Any law firm or any lawyer that is helping you with estate planning, at the end of the day, very specific instruction needs to be made as to how to title assets and who beneficiary should be, both primary and contingent. And that's part of good estate planning. That's a necessary, indeed it's an essential part, and the lawyer's role is to counsel that very specifically, very specifically. As to location of documents, absolutely. I'm not a fan of making too many copies, because then when you change it, you have to figure out where all the copies are. In terms of estate planning forever.
But it's not a bad idea to let people know where the documents are versus having copies all over the place. If there could be a centralized organizer that keeps these documents, that could save a lot of time and energy and make it easy to update over time.
No question. You got two organizational problems. One is the legal documents, to know where they are, where the originals are. And by the way, I'm not a fan of the lawyer keeping the originals. And the other organizational problem is the financial piece. Where are the assets? What institutions hold them? That's not part of the trust and will. That's a separate binder of data. Final point on estate planning is forever. It's really important to appreciate that an estate plan needs to be reviewed at least for an hour or so with the attorney about every 3, 4, 5 years. Things change. Tax law changes. People's lives change. The intention as to where the assets go change. If I see all the time people bring me in 20-year-old documents, and I am certain that those documents do not reflect now what the person that died would have wished.
Could I ask a quick question, Dave?
You bet.
What's the significance of having a copy of the will as compared with the donor not designating where the original is? I mean, what if you can't find the original?
Well, yeah, it's a really good question. If the original is missing, if I have a will and I die, and the original is missing, the question arises: did I intend to revoke it? Did I tear up the original? So the law in each state varies. But in Ohio, you have to jump through some hoops to get the court convinced that I did not intend to revoke that will, but a signed copy could be used in its place.
You know, where would you suggest, from your professional viewpoint, that an individual like me keep the originals?
My opinion is
other than in a bottom of my mattress.
Some of my partners will disagree, but I think you keep the originals first, not me, if I'm your lawyer.
Okay.
Second of all, I think you keep them in a fireproof safe, but only if your family knows the combination. not a safety deposit box, because once you die, Phil,
You can't get out.
you can't get in it. You can't get in it without a court order.
Good point.
I actually tell my clients, look, put them on the top shelf of your bookcase, in a nice, clear marked binder that says estate planning. If the fire takes them, I got a copy, so don't worry about it. I think it's less problem of losing them in a fire than losing them, period.
Okay, cool.
David, let's now, with those kind of the fundamentals in place of some of the jargon and language and the process, let's go through briefly a quick overview of the core documents that's the foundation to everyone's estate plan.
Well, the core documents depend upon the nature of the estate plan. Certainly a will, certainly a power of attorney for finances. General durable power of attorney is the proper name. Certainly health directives, so that my medical decisions can be made by others and what my wishes are. Depending upon the nature of the plan, sometimes other documents. I think the key is not to get lost in which document does what, but to be with a lawyer that helps you determine what your goals are, and then allow the lawyer to determine what documents are necessary in the simplest way to accomplish those goals. Certainly a will, certainly a financial power of attorney, certainly beneficiary designations where appropriate, certainly health directives.
And then a trust could be a core document depending on someone's objectives, and that would come out of that conversation with the client.
That's exactly right. People call me on the phone, Val, and say, do I need a trust? And my answer is, I have no idea. Because until we talk for an hour or two, I don't know what their goals are. And accordingly, I don't know whether the goals can be more easily accomplished with a trust or a will as a foundational document. There's no one answer. It's not a question of, well, if my net worth is below X, I need a will, and above X, I need a trust. That's a misconception and absolutely inaccurate. So, yeah, it comes from the conversation.
How do you deal with people that have pets? Is that something that's dealt with in the will or dealt with in the trust in Ohio?
Both. You can do it either place. That's, people really care about their animals. My kids are long grown, and my kid's now my dog. I really care about my dog, and I want to be sure that there's some process articulated in one of these documents that my dog is cared for, and maybe funds left, perhaps, that the person caring for my dog doesn't have to go out of pocket. There are even such things as pet trusts, where people that really want to provide for their animals long term actually create a trust so that the dollars are there, and they know that horse that's so precious to them will be cared for the life of that horse.
Not to be funny, but can I make my pet my executor of my will?
Well, we normally want actually humans.
Okay, I agree with it.
There's a couple of features in the power of attorney that we should be aware of, both for what we're dealing with asset management and then healthcare decisions.
Yeah, there are several kinds of powers of attorney. That's a good example of why you don't go to the internet for your documents. Do you want a financial power of attorney, a durable power of attorney that only is effective if I become disabled, or do I want it effective today? That's a judgment of risk, and that risk needs to be discussed. The selection of agents is very important. Should the agent be my son, my brother, my best friend, my law partner? And I will select a series of agents. If agent A can't act, then agent B can act. How is it determined if I'm disabled? By my treating physician, by my spouse, by two doctors? How is that determined? That's worth a discussion. So the duties and powers of that agent can be limited or can be very broad. Powers of attorney are often abused. People lose money from dishonest agents. Should there be a provision in the power of attorney that somebody else reviews the action of the agent once a year or once every 6 months? There are things to talk about to make sure those powers of attorney are well thought through.
And that's kind of important also as we move to the advanced health care directive, which is a different kind of a each state's got a different form of name for that particular document.
Sure does, and it's confused. In Ohio, we've got what I like to call financial power of attorney. That's not the right term, but I use that so it's not confused with healthcare power of attorney. A general durable power of attorney, a financial power of attorney, only allows the agent to, at certain times and under certain conditions, act on behalf of me if I'm disabled. And by the way, that power of attorney has no effect the day after I die. A nanosecond after I die, that power of attorney, that financial power of attorney has no effect. It also has no effect over trust assets, which is a common confusion. Only the next trustee can deal with trust assets. The healthcare power of attorney, we've talked about it, so we won't spend more time on that, I don't think, but a healthcare power of attorney makes medical decisions for me. And a living will tells what I wish to happen if I'm ultimately close to death. And I may or may not sign the living will. Final health document, I might mention, I don't mean to overtalk you, Val, is a HIPAA release. If my son calls the hospital and says, how's Dad doing, they're likely to tell him next to nothing because the hospital is afraid they will violate the medical privacy law, the federal medical privacy law. So I prepare for my clients a HIPAA release which says what people should be able to access my medical information so my son can talk to the hospital.
And do you work with quality of life statements as a way of letting an individual provide their feeling as to how to deal with these health issues for people making decisions for them?
You know, Val, I don't. It's a good question. I have some concern about that. First of all, it would be a non-legal document. My client could sit down and say, if I'm on a respirator for more than 3 days, I want it removed, and talk in general terms about quality of life. I have never gotten into helping them construct that. Perhaps some lawyers do.
Thank you. Phil, depending on people's financial condition and their personal goals, what are some of the charitable giving estate planning strategies to consider?
Thank you, Val. You know, this is a fun part of my life when I get an opportunity to talk at the invitation of a financial advisor with their clients. So these are the types of things that usually come out of the discussion. And sometimes it's done with the help of the financial advisor. Sometimes I add to it. But basically, there are a few things that really come out of this discussion. One is, you know, with the help of your trusted advisor, the financial advisor is assuring his clients that his assets have grown, or reminding him that his assets have grown. And with the putting together of the estate plan, the client is assured that they're taking care of their family's needs now and at the time of their death. They also talk about the discussion of being in a position where they would like to do something more. They would like the dissatisfaction of making the world a better place. Or maybe they want to be remembered. And remembrance is a very key thing in the charitable component of this whole thing, because it allows an individual to leave his mark for future generations. Nobody wants to die in insignificance. And so many times the client is facing really a rare opportunity, the opportunity to create an enduring legacy, something that they will be remembered for. And as you look at the various types of charitable giving options for creating the enduring legacy, you quickly discover that not one size fits all. And I'd like at this point to talk about the one option, donor advised funds. They're called DAFs. First, they were developed back in the 1980s by community foundations, and then they were really popularized in the 1990s and even up to today by the national commercial and the independent donor advised fund sponsors. They are now the most popular form of charitable giving in America today, more so than any other charitable giving vehicle combined. Why? One, they're very, very simple. Donor advised funds are incredibly simple to set up and operate. You know, if you were looking on a complexity scale of 1 to 10, donor advised funds would be a 1. A private foundation might be a 10. There might be other vehicles that might even be more than 10 out of a scale of 1 to 10. But a donor advised fund is typically a 1. It's very, very simple, very easy to set up, very easy to understand. Secondly, they're very tax smart. They offer the highest tax benefits available, more so than those of a private foundation. Thirdly, they're meaningful. This is a very, very simple way to engage your family in passing on your values to the generations to come in really meaningful ways. How do they work? Well, they're very simple. You can set up one for as little as $10,000, some of them even as $5,000, by making a gift to a public charity that sponsors a donor advised fund. In fact, in our model, you can even create one with no funding at all now, but rather through your will and provisions in your estate plan, funded at the time of your death. There's typically no cost at all to set up something like that. Secondly, your assets are placed into an investment account. Call it sort of a charitable investment account. And it's managed typically, in our model, by your own financial advisor, if you so choose. At that point, you can recommend grants from this charitable reservoir really to support any charity you're interested in supporting, and more importantly, on your own timetable. There is no regulatory timetable that says you must distribute these every year, so you can take your time if you want. You identify who's going to succeed you in the event of your death. So in essence, your legacy can go on to your generations to come, over multiple generations. You can use your charitable legacy to teach your children and pass on family values to children and grandchildren. I think some of the most rewarding stories I hear from our clients is how they're using their donor advised fund to teach their children and their grandchildren. In fact, in our particular model, we allow children as young as 8 years old to participate. And the letters that go back and forth between the grandparent and the grandchildren, are really heartwarming. You can use your donor advised fund as a focal point for other planning strategies that you already have in place. For instance, if you have life insurance programs, they can be designated as beneficiary of your life insurance. Actually, with regard to life insurance, they can actually be the owner and beneficiary of your life insurance, in which case there's some significant tax advantages for doing that. You can name your donor advised fund as as beneficiary of your retirement plans, 401k plans, or individual retirement plans. You can name your donor advised fund as beneficiary of your charitable remainder trust or your charitable lead trust. And so they work very, very well together. You can even use your donor advised fund as a complement to your private foundations. And that works really well. By really so doing, you really supercharge the private foundation, because in some cases, you can do things in a donor advised fund you can't do in a private foundation, and vice versa. So by having both, you're really, really offering the best of both alternatives to your client.
I want to add something to that, Phil. I just learned a fair amount from what you said. One of the things interesting to me, among several you just said, is that I could advise a client to write a will or a trust,
yes,
and leave X percent, 1%, 10%, or a specific dollar amount into a now empty donor advised fund.
Nothing, it doesn't cost anything.
So we get it all set up, but it only becomes effective when the money is placed into it at my death.
It's called a legacy fund, yeah.
And then my kids could direct and advise what charity each year after I die should be funded by that sum of money.
That's all like
that's huge. There's all sorts of charitable reasons.
Interesting about that, it becomes a component of the estate plan. Because when you set up the infrastructure for doing a donor advised fund, you're identifying who the donors are, what their names are. You're identifying, if the donor chooses, what's the purpose of the fund for future generations to know. You're identifying the name of the fund, so you're capturing what's in the mind of the donor at the time it's set up. You're identifying who the successor advisors are to take over after their death, after you die. You're also identifying how the fund is going to be distributed at the time of your death. Is it going to continue on as a donor advised fund, or is it going to be paid out over a period of time, or is it going to be paid out as an endowment, for instance, in your memory, virtually forever? So in essence, you're also identifying who the financial advisor are, and you're identifying who the attorneys are. So in essence, everything is in place. There's nothing in it. And at the time of death, it just all of a sudden evolves and is funded, and it just goes on.
Good measure of an attorney is whether he asks every client, what, if anything, do you care to do for charities when you die?
So really the point I make to donors usually at this point, congratulations. You're about to enter probably a new and really exciting phase of your life, and I call that the phase of significance. And that term significance all of a sudden says to the individual, wow, I am significant, and I can make a significant impact by creating my legacy.
Thank you, Phil. That's excellent. There's a number of advanced estate planning tools which we won't go into in our presentation today, but we've got noted up there to give you some ideas. Once that core estate plan is put together, then additional things like Phil's talking about in the charitable side and also in protecting your assets from liability issues, and if you have large estates, being able to pass on assets intact for generations to come. The next slide has a tool for you that is designed to try to help demystify this complex concept and to help put together a powerful six-step process to successful estate planning. And this process, if you've already put your estate plan together, can be utilized time and time again to help you keep it up to date. And for clients or potential donors, helping them understand this process makes the whole estate planning function more effective in a time-consuming manner and on a cost-effective manner. We'll go into this, or you'll see this in more detail in the materials that will be provided to you in the next day. As a planning tip, being able to get organized before you go in to see the attorney can help make the conversation with David or your estate planning attorney more effective. If the clients can bring you in this type of information, does that make your conversation, David, more meaningful with the client? Does it help get their thinking together to give you the best tools to put the documents together for them?
Yeah, it certainly does. The more information we have about, obviously, the better and the more efficient these discussions will be. I will say that I've hesitated in my practice to give out this list to the client before I've met them because I think it may be intimidating enough that they don't know where to begin. But this data, in an organized fashion, as soon as possible, makes all the difference in quality estate planning.
And for those that are in the audience that are advisors that can help gather and organize this data for the client, that takes the intimidation factor away and gives them the tools for the client and the attorney to be able to make the best use of time. And also the team approach, because as the situations get more advanced, being able to have the attorney, the accountant, the financial planner, the insurance agent, a charitable representative, be able to work together to effectively provide insight either to a current situation or to a planning situation can be quite meaningful, whether that's in a group meeting or a group phone call.
Val, I know we're out of time, but I do want to confirm that. The best plans that I generate are routinely those where the financial planner is encouraged and welcomed by the client to sit through these meetings because they know things about the assets that I don't. They have strategies in place that I don't know about. And to work as a bona fide team is hugely valuable to me.
And I find in my own personal experience with my own estate plan, I just got an email today from my financial planner saying you were supposed to have identified the contingent beneficiaries of a particular plan I have. You were supposed to deliver it to your company. Have you done it? So basically, he's acting as a follow-up to make sure I'm doing my job, and I think that's a good ingredient to have.
Well, and that kind of brings us to this slide that's up there now, is the estate planning mistakes to avoid. Going through estate planning, like the financial planning quiz that we took at the beginning, missing any one of these elements under the wrong circumstances could be financially devastating to you or to your family and loved ones that need to deal with the affairs afterwards. So you might take a look at this checklist and see how that relates to you and to make sure that you address these items if they're not already addressed. And if you're an advisor, using this as a checklist also for working with your clients. The next slide deals with some finishing touches. Once these documents are in place and drafted, David, what are some of the other finishing touches to complete the estate plan and then to make sure they're kept current for the rest of the people's lives?
Well, I can only tell you what we do. Excuse me. My clients end up with a binder of the documents with the proper tabs so they can find their way around the documents. That's a clear way to organize estate planning documents. The binder says in bright green letters, estate planning on the side of it. That's easy to organize, but it should not be in just a box or a file with a bunch of copies that aren't signed and copies that are signed. The originals need to be properly organized, bound, and kept safe, as we've talked about. That does not handle the organization, as we've talked about, of the financial assets. The financial planner is more the person that can help with that. Let's get all the life insurance listed. Let's get all the assets listed, the retirement accounts listed, the real estate listed, maybe the account numbers. Passwords for digital data need to be filed somewhere. That's often overlooked. Organization is just key. It's not complex. It just takes some work.
And this was having like a location sheet that doesn't necessarily have primary information in it, like your Social Security number or driver's license, but a location sheet that says you can find my estate planning documents in a financial organizer, in a fireproof safe at home. You can find my annual financial statements in that organizer. You can find my tax returns in that organizer. It gives you the tools to be able to keep things together. A thought that you may want to think about is consider your family as a family office and treat it as one. Treating the family as a family office, from grandparents, yourself, kids. Over the years, wealthy families have created a family office and hired financial professionals to watch over the family wealth and to help family members better manage their finances and resources over the years. However, you don't need a lot of wealth to also do this. Just keeping your family, talking to your family about finances is very important. And help them keep and encourage to do estate planning in each of these areas for each generation. When you combine 3 generations together, some real magic can happen. Today, this is important for families with modest wealth as well as for very wealthy. Estate planning is truly a lifelong process. Over the years, many folks have told us they plan to get their estate and financial plans in order if they only get around to it. If this is your situation, we have a little surprise for you. Here's your round to it. You now have the basic building blocks to successful estate planning and keeping your estate plan in order for now and for your lifetime. In our short time together, we hope we've enlightened you and demystified the estate planning process and shared the basic building blocks to estate planning with you, giving you some tangibles to walk away and help you better understand the prices so that you can discuss issues with your spouse, life partner, and family. And lastly, motivated you to take action to keep and get your estate planning house in order. Now's the best time to create or update your estate, as you'll never have more time than you did today. And if you need another round to it, just give Phil or Eric a call. Before we open up for final questions, on behalf of our distinguished presenters, David Umbaugh, Bill Tobin, and Eric Kinaitis, the American Endowment Foundation and the Financial Awareness Foundation, and yours truly, Valentino Sabuco. Good luck with your estate planning, and happy National Estate Planning Awareness Week.
Thank you, Valentino. In deference of time to our audience, we have reached the conclusion of our time together today. As we did state earlier, anybody that had sent us any private questions, we will respond to. And as a awareness for our audience, this webinar has been recorded, and we will be promoting out sometime in the next week how you're able to access that recording. So if our audience members desire to review this presentation again or to share this presentation with their clientele, they may do so. Again, thank you for joining us today. We appreciate your time.